Everybody to National Action Network. My name is Michael Harting. I'm General Counsel here at the National Action Network and have the honor of having been asked by the committees to moderate today's panel. For those of you that don't know, the president and founder of the National Action Network is the Reverend Dr. Harting. Now, let me jump right into the panel. We have a great panel, an expert panel that is here this morning. Of course, it's an important issue, and I will introduce each of them, not in the order necessarily that they're going to speak. I already told Senator Geonaris that I would put him up first, and and you know, we'll start off that way. But let me introduce the panelists. To my right is Tanya Greene. Tanya is a, Tanya Greene, right? Yes, okay. Tanya Greene is a graduate of Harvard Law School. She currently serves as an advocacy and policy counsel at the National ACLU office. She's also affiliated with the Center for Justice. Ms. Greene has worked as a capital defense practitioner for almost 15 years. Her travels have taken her through stints with the Southern Center for Human Rights, served as a death penalty resource counsel for the National Association of Criminal Defense Lawyers, and she served as a deputy capital defender in the New York Capital Defender Office. Welcome to the National Action Network. Attorney Anthony L. Ricco is a graduate of Northeastern University School of Law. Mr. Ricco is a renowned criminal defense practitioner. His practice focuses on state and federal criminal defense and capital defense litigation. You know, when I talk, I can hear all the buzz. So y'all need to, if you're not going to participate, you need to step out. Mr. Ricco, his practice focuses on state and federal criminal defense and capital defense litigation. He is a member of the Criminal Justice Act and capital panels for the Southern and Eastern Federal District Courts. He has represented death penalty cases across the country. In October 2009, he was appointed as a National Resource Counsel to the Federal Death Penalty Resource Council Project in Frankfort, Kentucky, and in 2010 was accepted as a fellow in the American College of Trial Lawyers. Welcome, Mr. Attorney Ricco. There are other great things, and by many of the people on the panel I know personally, and I'll leave it to them to highlight other aspects of their illustrious careers. To my immediate right is Professor Robert Blecker. He's also a graduate of Harvard Law School. Professor Blecker has been teaching at New York Law School since 1975. He teaches courses in constitutional history and criminal law. He served as Special Assistant Attorney General, served in the New York State Office of Special Anti-Corruption Prosecutions. He's a leading authority on the death penalty and a frequent commentator on national news programs. And you'll hear when he speaks, he's one of the few people who are pro-death penalty. He is a prolific writer and author and has recently completed Let the Great Axe Fall, Vote No, and a documentary entitled Robert Blecker Wants Me Dead. He has countless law review and other scholarly publications. His one downside is that he had to endure me as one of his students at New York Law School. Lawrence Ghana Hayes was born and raised in Harlem, USA, right here, that is. In 1968, he became a freedom fighter when he joined the Black Panther Party for self-defense. One of their goals was to eradicate the distribution of heroin in the black community. On August 21st, 1971, while surveilling a drug drop spot in Queens, he was arrested and implicated in the death of a New York City police officer. He was convicted and sentenced to death. He was one of the 5 New York State death row inmates in 1972 when the U.S. Supreme Court declared the death penalty unconstitutional. Of course, since then, they have reinstituted it. He was paroled in 1991 and has since become a noted spokesperson against the death penalty. Lawrence is the co-founder of the grassroots campaign to end the death penalty. And of course, we have two of our elected officials. All right, here we go. Senator Michael Geonaris is from the, represents the 12th Senate District in New York State. Senator Geonaris was elected to the State Senate in 2010 with 81% of the vote after publicly serving in the State Assembly. He's the first Greek American to be elected to office in New York City and has assisted his community and state with unique effectiveness. He also ran for Attorney General. Senator Geonaris introduced a death penalty bill in 2005 when he was a member of the Assembly. The purpose of the bill is to create an independent commission to review and study cases of exoneration and issue reports, recommendations to prevent further death penalty convictions of innocent individuals. He's a graduate of Fordham University and Harvard Law School. I think we have a Massachusetts bias on the panel. Although Mr. Ricco didn't go to Harvard, he went to law school in Massachusetts. All right. Last, but certainly by no means not the least, and clearly a true friend of the National Action Network, Eric Adams was here in the early and founding days of the National Action Network. He may not remember it, but his name and signature is on the founding documents of the National Action Network. On November 7, 2006, following a distinguished 22-year career in the New York City Police Department, Senator Adams traded his blue uniform for a blue suit. When the residents of the 20th Senatorial District elected him to the New York State Senate, he was also re-elected in 2008. Senator Adams is best known for his efforts to create a more symbiotic relationship between law enforcement and the residents of New York's diverse neighborhoods. He has helped thousands of youth throughout New York learn to interact more appropriately with the police by using conflict resolution. Throughout his years in service, he has joined forces with hundreds of community groups and organizations concerning public schools, urban economic development, affordable housing, civil rights, and political accountability. He's also served as ranking minority member on Crime and Correction Committee, as well as Veteran Homeland Security and Military Affairs Committee. So welcome, Senator Adams. On a bright note, on Thanksgiving of this year, and this, those that are involved in death penalty work, it's very remarkable, and many of us really admire, because it is a lifetime commitment. When once you're in it, you can truly be in it for the rest of your life. And victories, while more frequent now, are not always there. But one recent that was in the news is that the governor of Oregon, Governor Kitzenhauer, I think his first name is John, just announced a moratorium on the death penalty in the state of Oregon. So before we go to our first speaker, there are some real basic facts about the death penalty. I'm just going to throw out some. The speakers will really take care of the rest, but these are really basic. The states in the United States that continue to have death penalty is 34. States without the death penalty is 16. The race of defendants executed is 55% white, 35% black, 8% other, and 2%, 2% is other, and 8% is Hispanic. The race of the victim in death penalty cases is 76% white, 6% Hispanic, 15% black, and 3% other. So, the statistics are interesting in this, and I'm sure the panelists will get into it, but I am going to start and invite Senator Geonaris to lead us off. Oh, before he goes, let me just say, I'm sorry. The way that we will do this, as you see, we have a full panel, so we want to give each of the panelists an opportunity to introduce themselves to you and provide you with whatever information they believe would be very helpful for you to have, after which we will open it up to you to ask questions that interest you, to any of the panelists. I will fill in questions that may be appropriate here and there, but the real opportunity is for you to have the benefit of the panelists, and for the panelists to have the benefit of you, because many of you are on the ground in some of these cases. So that's how we'll do it. Senator.
Thank you, Michael. Good afternoon. My name is Mike Geonaris. I'm a colleague and friend of Senator Eric Adams in the State Senate. I know my audience. And I have been in the state legislature for 11 years, now 10 years in the State Assembly and 1 year in the State Senate. You know we have a lot of Harvard Law graduates up on this panel. I have the distinction of having been there at the same time that President Obama was a student in the early 90s. Had I known he was going to be president back then, I might have played my hand a little differently. I've been in Washington right now, but it is a pleasure to be in the State Senate and serve in the public. My first job...
You'll have 4 more years to do that.
That's right. That's right. That's right. My first job in government was working for Governor Cuomo, but not this one. The father, Mario Cuomo, who, as it relates to the death penalty, was a firm opponent of it at a time when it was much more of a hot-button issue even than it is today, and some would say that helped cost him his re-election in 1994. But he was nothing if not a man of principle on this issue, and helped frame my own viewpoints. Throughout my tenure in the Assembly, now in the Senate, I have been consistently opposed to the death penalty for a number of reasons. I mean, we could talk about, and I'm sure we will talk about, the fact that I don't believe it serves any deterrent value whatsoever, so from a criminal justice perspective, other than pure hatred and vengeance, I don't really know what purpose is served by it, and I don't think our government should be in the business of doling out punishment for those reasons. The issue of racial disparity is one Michael touched on, and there are others on this panel who could speak more authoritatively about it than I can, but the one thing I keep coming back to, and it's a fight I've been leading for the last 5 or 6 years, is the issue of exonerations of innocence, of wrongful convictions, as it relates to not only the death penalty, but all crimes. And I think there are a few things our government can do that are more abusive and more offensive than either taking away someone's liberty or his or her life for something they didn't do. And it happens way too often, and one of the ways that other states have dealt with it is what I proposed here in New York, is the establishment of a commission to evaluate these cases. When something goes wrong, when someone is convicted, when they shouldn't have been convicted, we have an obligation as a government to step in there, find out what happened, find out what went wrong, and then change the criminal justice system to keep it from happening again. So there are all sorts of recommendations that can come out of these cases, whether it's videotaping confessions, or stricter criteria for DNA sampling and the use of DNA in exonerations. We're not doing nearly as much of that as we should, and no matter where you fall on the issue of tough on crime or not tough on crime or whatever political side of the issue you're on, exonerating innocent people is an easy one, right? Because these are people that didn't do anything wrong to begin with. They shouldn't be in jail, they shouldn't be on death row. And in the meantime, when the wrong person is in jail, that means the right person's out on the streets, walking around and still committing crime. So I would argue that an aggressive government position for exonerating the innocent and an aggressive effort to exonerate the innocent is actually a tough on crime position, because it gives us a greater chance of finding the real perpetrators who are still out in the public. So that is the approach I've taken on it. I also believe, for a whole host of other reasons, that the death penalty is just not good policy for government, but the angle I come at it from is from the fact that there's no going back if we put to death somebody who didn't commit a crime. They're gone. And we've seen it most recently in the case of Troy Davis. I'm sure everyone's familiar with it. The man was convicted on the basis of eyewitness testimony alone, and I think 7 out of the 9, is it, later recanted, and somehow that fell on deaf ears in the state of Georgia, and we know that unfortunately he's been put to death, and if it is discovered tomorrow that there's dispositive evidence that he didn't commit the crime, what are we going to do about it now? And so the death penalty, aside from being a moral problem for me, it's also a practical one that I hope we certainly don't see come back here in New York. We don't have it here, thank God. But it still exists in other states throughout the country, and the more we can move the debate against it, the better off we'll be.
Right. Thank you. Ms. Greene, or Attorney Greene.
All right, thank y'all for inviting me to participate here today. I really appreciate the opportunity to talk to folks about the death penalty, which is near and dear my heart because I've had family members face the death penalty. I've also had family members murdered, which puts me in a strange position, but definitely one where this resonates over and over for me. I am an advocacy and policy counsel at the ACLU, the national office, which means I work with all of our state affiliates on criminal justice issues, including the death penalty. And today I want to talk a little bit about one of the issues in the death penalty that really resonates for me, that is something that I think we can't stop paying attention to, and I don't believe the National Action Network would ever, and that's race and the death penalty. And there are real horrors about the death penalty in terms of race, and Mr. Harting started with them a bit, and I want to go into a little bit more of the statistics because they're so shocking. I think they stand for themselves, they speak for themselves. But then I also want to talk a little bit about hope on the front of the race front in terms of the death penalty, because there are things that are being done across the country, and there are things that you all can do and that we can do hand in hand to work on this issue. So for the horrors. The death penalty system is biased against those who are convicted of killing whites, and that means 75% of the murder victims in cases where the defendant was executed were white. 75% of the murder victims. Nationally, though, only 50% of murder victims are white. The death penalty system sentences blacks disproportionately to death. So 35% of those executed so far in this country have been black, 56% white. 35% of those executed, where we have a population of at most 13% black countrywide. Despite what the media and the TV cop shows would have us believe, most murders are intraracial though, white on white, black on black. But the fears that whites have that blacks are more likely to kill them than kill each other or kill other blacks or other people of color is inaccurate and unfounded. And we need to keep that in mind when we think about how folks are talking about the death penalty and not let it slide into this kind of black on white thing that people think is real and predominant when it's actually not. 86% of white victims in death cases were killed by whites. 94% of black victims in death cases were killed by blacks. Oh no, I'm sorry, not just in death cases, overall. Blacks and whites are murder victims in almost equal numbers of crimes though, which is terrifying when you think about the percentage of black folks in the population. So blacks and whites are equal numbers of murder victims. So the next question is, do blacks commit more murder than whites? And is there some kind of reason that these disparities exist? Actually, though, the federal government, stands me up on this because I get these stats from them. African Americans are 6 times as likely as white Americans to die at the hands of a murderer. African Americans are roughly 7 times as likely as others to murder. However, young black men are 15 times as likely to be murdered as young white men. So being black is dangerous, we know that. We walk down the street every day, especially in certain neighborhoods where the police are more likely to kill you as protect you. Resulting in the huge numbers of problems that black communities and young black men in particular have settled through deadly violence. And so the death penalty is its own issue on its own, but it speaks to violence in our communities that we need to pay attention to. So I want to turn a little bit to some case law because I'm a lawyer and that's what I'm supposed to talk about, right? But there's a case called McCleskey v. Kemp that was decided by the United States Supreme Court in 1987. It came out of Georgia. And in 1987, the U.S. Supreme Court decided this case and effectively crippled all defense efforts to be able to effectively object to racism in capital cases. In the McCleskey case, evidence was presented that of a study of 2,000 cases between 1976 and 1980 in Georgia, established that blacks were murder victims in 63.5% of the cases, but that in 82% of the cases where the death penalty was imposed, the victims were white. Prosecutors more likely seek the death penalty when victims are white, and jurors are more likely to impose the death penalty when victims are white. This is the information that was presented to the Supreme Court. A defendant charged with murder of whites would receive the death penalty in 11% of the cases, whereas the defendant charged with murder of blacks received the death penalty in 1% of these cases. Blacks who kill whites are nearly 22 times more likely to receive the death penalty than blacks who kill blacks. And this was all statistical information that was presented to the U.S. Supreme Court on a claim that there was a little bit of a problem. Defendants charged with murder of whites are 4.3 times more likely to receive the death penalty than defendants charged with murder of blacks. And that's the sticking point, 4.3 times more likely. But the Supreme Court, despite finding a discrepancy that appeared to correlate with race, which they admitted, that's there. We can't pretend that these statistics don't exist. So we accept that information, even if we accept that information, though we refuse to find an 8th or 14th Amendment constitutional violation because the proof of intent was absent. So you didn't have the prosecutor standing up and saying, I'm gonna get me that nigger, and then proceeding to charge him with the death penalty. And that's the intent that the Supreme Court wants. And you don't ever really get that. And the problem now is, since 1987, the Supreme Court McCluskey decision has stood, and there has been no case that has succeeded, a race claim that succeeded under McCluskey since 1987. We've been basically stymied by it. It was a 5-4 decision, and interestingly enough, Louis Powell, the Supreme Court Justice, one of the Supreme Court Justices who sat on that case and sat on that decision as when was one of the 5 in the majority to turn down the claim, wrote in his memoir that that was a decision that he most regretted and wished that he could have done differently. But we're stuck with it. So, what do? Justice Brennan, who is was one of our heroes on the Supreme Court during the time that he was there in terms of the Constitution meaning something in real practical life, lamented in the dissent of the McCluskey decision that the court was really afraid of too much justice, that if they really addressed the racism and the race bias that they saw, that they couldn't ignore, then the whole system would come down. Because this was 2,000 cases over 4 years in the state of Georgia, pretty reflective of what's going on in the country as a whole. There is actually, I don't know if you all are familiar with Brian Stevenson, who heads the Equal Justice Initiative in Alabama, who does incredible civil rights, racial justice work on behalf of death row inmates and prisoners all around, as well as kids charged as adults and kids charged or sentenced to juvenile life without parole. But Brian has always said that there's actually a greater likelihood that the race of victim will impact whether you get the death penalty than the fact that cigarette smoking causes cancer. But which of those facts are we more likely and is more easily accepted? And we should really pay attention to that. You know, the statistics bear out that race is more determinative than cigarette smoking is, but we just can't, as a society, handle that. I think I had too much prepared things, so I'll go to some questions later, but I wanted to give you all a little bit more before I finish on the hope, because it's not all hopeless, it's not impossible. We can do lots of things to make a difference on individual cases, and maybe Tony Ricco is going to talk a little bit about that, what you can do in individual cases to ensure justice. But then also wholesale, as community folks, as legislators, as citizens of this country, citizens of individual states. Until we morally advance as we should and decide that the death penalty is not for us on moral grounds, we can use the example of the state of North Carolina. In 2009, North Carolina passed what's called the Racial Justice Act. And is anyone here familiar with the Racial Justice Act? Ever heard of it? I've heard of it. Okay, so it was in direct response to McCluskey, and it was an attempt to institutionalize the ability to make claims by capital defendants who are already on death row or individuals who are facing the death penalty, and present evidence, including evidence of statistics, that race would play a part or had played a part in their capital conviction. And it was an explicit attempt to, or it is an explicit attempt to allow for information like historical detail of the county practices, the prosecutor's patterns of discrimination in jury selection and selection of who's going to face the death penalty and who's not, the types of crimes and things like that. All that kind of evidence would be able to be presented under the Racial Justice Act. And it's clear that the RJ is needed, and particularly in North Carolina, it's interesting to note that since 2007, which is only 4 years ago, 3 black men were released from death row in North Carolina due to innocence. All 3 men were African American. In all of the cases, at least one of the victims was white. One of the men was sentenced to death by an all-white jury. The Racial Justice Act ensures that no one will be sentenced to death based on the color of their skin and the color of the victim. These 3 men were released right around the time the Racial Justice Act came to be. And so the district attorneys and the naysayers who said, we don't need that, North Carolina is fine, I had to face then this media of 3 guys walking off death row. And you know, by the skin of their teeth, as we know, people do get executed despite innocence.
That's right.
So it's not something that, you know, we can pretend is just a theoretical problem. This is a real problem. And so then also in 2010, then after the RJ was passed, 2 studies were released about the North Carolina death penalty system itself. Again, establishing that there were major race problems.